Even if there is a change of law, even if the legislature says now this is the law, this common law principle said there has to be an end to litigation.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Today we're unpacking a growing appellate split in New York foreclosure law that could have major implications for lenders, servicers, and foreclosure practitioners statewide. Specifically, we're looking at whether a defendant can move to dismiss a foreclosure action based on a FAPA amendment after a judgment of foreclosure and sale has been entered, and more importantly, whether they can do so even after the time to appeal that judgment has expired. In Deutsche Bank v. Goldwasser, the third department held that such a motion is still fair game up until enforcement of the judgment of foreclosure and sale. But the first department reached the opposite conclusion in U.S. Bank v. Gallant, ruling that once the appeal period ends, that door is closed. The second department hasn't weighed in yet, and the fourth department, based on FLA Capital versus State of Paul, seems more aligned with the first. With this level of inconsistency among the departments, we could be heading towards an intervention by the Court of Appeals to settle this issue statewide. Joining me to break it all down are Friedman Vartolo partner Zach Gold and Stephen Vargas, our senior appellate counsel. We'll walk through the case law, examine the appellate split, and talk about what this means for pending and future foreclosure actions in New York. So Zach, before we jump all the way in, you want to just give us some legal background on where we are?
Sure. A couple key principles involved here that sort of give us a framework for this discussion. So the first is the common law principle that once a final judgment has been entered and the time to appeal expires, the common law said that you are barred from relitigating any issues. You're barred from challenging that order. Even if there is a change of law, even if the legislature says now this is the law, this common law principle said, there has to be a cutoff. There has to be a certain point where litigation is resolved. There's one seminal decision that discusses this called Matter of Hugh. It was a 1967 Court of Appeals decision where they said, even though this may create a harsh result, the fact that the law has changed, there has to be an end to litigation. And that once the time to appeal a final judgment has expired, that judgment should remain inviolate, meaning free from any challenge.
What's interesting here is our conversation today is about whether or not FAPA amendments can be brought up post-judgment.
Exactly, that's the scope.
Just to provide you a little bit of background. So we have this common law principle, as we discussed, that once a judgment is final and the time to appeal expires, you can't challenge it based on a change of law. And then the legislature in 1999, I believe, specifically articulates how one would challenge an order based on change of law in CPLR 2221E. And then after that specific legislative enactment, we have decisions analyzing the time frame. So we have this seminal case of Glickman v. Board of Education, where they preserve the finality of a judgment, they preserve the common law principle, but they also specifically say, when analyzing CPLR 221E, that there's no indication from the legislature that they intended to change this common law principle of the finality of a judgment. So it really sets the framework for our discussion, because what happens in the case of FAPA, what happens if the legislature does give some indication that they want to amend this common law principle? And I think that's what resulted in this split between the first department and the third department as far as their interpretation of, has the legislature specifically articulated that they are amending this common law principle that a judgment is final, and even if there's a change of law, you can't challenge it? Has FAPA created that exception to the common law principle?
Is the conversation on whether FAPA's created a carve-out of the common law principle, or is it literally like, did the legislature mean to do away with the common law principle entirely?
In the context of FAPA?
Join us next week for part 2 of this episode.